eventual abolition of native slavery in revolutionary Virginia and its racial legacy. It says here in the introduction, in 1772, George Mason, later famous as the father of the Bill of Rights, represented a slave named Robin and 11 other enslaved plaintiffs in the General Court of Virginia, the colony's highest court. The slaves claimed that maternal descent from an American Indian made their enslavement illegal. So they were fighting that they were Indians and shouldn't be enslaved. And Mason marshaled arguments from natural law and statutory history to support the contention. In a terse, one-paragraph opinion typical of the era, the court agreed freeing the plaintiffs and ordering their former masters to pay them nominal damages. So you hear that these so-called, they were being tagged and labeled as slaves. They went to court. They were able to prove they were American Indians, and the court agreed, right, freeing them and actually paying them back for any damages, right? So this court case was called the Robin versus Hardaway. This was from 1772, if you want to look it up, right? Freedom suits were common in colonial Virginia. Although defined as property for almost all legal purposes and denied rights of citizenship, slaves could allege illegal enslavement and sue for their freedom. So did you know slaves could sue for their freedom? Courts recognized such claims throughout the slaveholding South from slavery's 17th century beginning, so we're talking about the 1600s, onward. These suits offered one of the few routes to manumission in early America. The ordinary posture of the Robin versus Hardaway case, though, belied its extraordinary result. The court's decision marked a watershed in the legal history of Virginian slavery. It was the first recorded holding of an Anglo-American court that maternal descent from American Indian alone established the right to freedom. This outcome was remarkable in the context of early America, where despite present-day conceptions that all slaves were Africans, Indian slavery was ubiquitous. All right, you hear that? Not all the slaves were so-called Africans or people they were bringing from the Caribbean. Indian slaves could be found in all 13 mainland British colonies in 1772. So again, this article has footnotes, right? And you can see the sources, a lot of verifiable scholarly university legal sources, all right? So that's why I'm reading this article. Continues, says, in Virginia alone, thousands of descendants of enslaved Indians toiled alongside African slaves on the plantations. Thousands of descendants of enslaved Indians. Robin versus Hardaway repudiated this history and deemed the previously common institution illegal in all but a few circumstances, inaugurating a line of cases that culminated in 1806. In the end, Virginia court concluded that enslaved descendants of Native Americans were prima facie free, judicially abolishing Indian slavery in Virginia. This precedent spread throughout the antebellum period. Courts in Connecticut, Louisiana, Missouri, New Jersey, South Carolina, and Tennessee all grappled with Virginia's decisions and debated whether maternal descent from American Indians was sufficient to establish freedom. Explaining this shift in the racial basis of slavery and more difficult than observing it, the Robin Court and its successors claimed merely to be engaged in statutory interpretation, and Mason argued for Indians' freedom on the basis of the libertarian principles of the Revolutionary War. This comment argues, however, that the ultimate grounds for this doctrinal innovation lay deeper in the changing demographics of early America. Although not the judge's conscious motivation, Robin and his progeny solidified chattel slavery rather than weakening it. By making Indians legally white, you hear that? By making Indians legally white or black, as we shall see in some instances, the court erased a complex triracial past and created instead a society legally divided into the stark categories of free whites and enslaved blacks. This erasure has present-day legal consequences for federal tribal recognition, struggles over tribal membership, and interpretation of the Equal Protection Clause. And and we see this a lot going on right now. To understand the nature of this transformation, this comment builds on two previously unconnected bodies of scholarship. A growing literature on early American history examines the formerly neglected role of Indian slavery and argues that the institution was far more widespread and important than previously thought. All right, so you hear that. We're getting this from another person that, Indians were being enslaved, not just so-called Negroes or so-called Africans. These works rely heavily on court records, deeds, and other legal sources and acknowledge the law's importance and passing, but they neglected the legal history narrative. By ending their chronologies in the mid-18th century, they overlooked the complex judicial debate over the legacy of Indian slavery in revolutionary and antebellum America. By contrast, freedom suits, including those involving plaintiffs claiming Indian descent, have received sustained analysis from legal historians as part of a larger literature on cases of racial determination in which the central and often sole legal issue was a person's racial status. In these instances, faced with the reality of a mixed-race society that rarely aligned with legal categories, courts turned to a variety of methods: appearance, ancestry, science, and reputation, to classify ambiguous individuals, thus laying bare to historical criticism the constructed and arbitrary nature of legal conceptions of race. Robin and its progeny, though, fit uneasily into the conceptual framework. First, as with American legal history, more broadly, the current scholarship on racial determination focuses primarily on the period between independence and the Civil War. This periodization ignores the first 200 years of racial construction in America, making cases such as Robin that grapple with the colonial legal legacy unintelligible. So what she's basically saying is that they really only took us back to a certain period of time. They didn't go further back, because if we really went further back, we will see what was going on with the American natives and how they were becoming slaves or Negroes or classified as white, and how much Indian slavery was really going on. But they don't take us back that far when we're in school learning in these classes, American history. Second, Robin and its progeny were not racial determination cases. Their outcomes hinged on the legal consequences of Indian descent, not on the plaintiff's racial identity, which both sides usually acknowledge as Indian. They were applications of racial ideology rather than determination of racial identity. Since the literature on neither Indian slavery nor racial determination alone provides a complete account of Robin and its context, this comment draws on both to understand fully the causes and significance of the doctrinal transformation and racial construction that the case epitomizes. In particular, this comment argues that the racial formations of the antebellum United States cannot be understood without reference to its earlier colonial history. The black-white divide that emerged during the Revolutionary period was neither natural nor organic. So that started in the Revolutionary period. We're talking about the 1770s, 1700s. Rather, it represented a conscious repudiation of an earlier triracial era by judiciary anxious to reinforce race-based slavery. To support these contentions, this comment is divided into 4 sections. Part 1 discusses the colonial history of Indian slavery and race in early America, broadly and in Virginia specifically. Part 2 delves more deeply into Robin and its successors, examining the evolution of the court's reasoning on the legality of Indian slavery. Part 3 probes the various explanations for the decision to grant freedom to enslaved Indians. And finally, Part 4 explores the legacy of these cases in the antebellum United States, as well as the implications for contemporary legal issues surrounding tribal recognition, tribal membership, and the Equal Protection Clause. All right, so this was the introduction. So part 1, again, the hidden history of Indian slavery in Virginia. And it says here, A, the origins of Indian slavery in early America. The prevalence of African slavery in North America was not inevitable. That's your own hijack. The fantastic prosperity of Spanish South America rested on forced Indian labor. Again, the Spanish were enslaving Indians. They weren't bringing Africans, they were enslaving Indians. That the Spanish and Portuguese were bringing Indians by the thousands to Europe, West Africa, and all the rest of their colonies in America. All right. Although Spanish colonists employed labels other than slavery for these practices, after the Crown abolished Indian enslavement in the 16th century. So what they're talking about is that they gave different terms. They weren't calling these people slaves, these Indians. They were calling them indentured servants or encomiendas in Spanish, which means like a loan, like you have a loan or a contract. Eyeing and envying Mexico and Peru, the first English theorists and colonizers envisioned freeing the oppressed natives from Spanish tyranny. So listen to what they're saying. They're saying that the English were paying close attention to the Spanish, right, and the Portuguese. They're not naming the Portuguese here, but they were seeing what they were doing, which was enslaving the Indians and having free labor and building their colonies with these Indians and enslaving them, having them work in the sugar cane plantation and stuff. And this is before so-called slavery. This is before the plantations in the United States, all right? Talking about the Caribbean, Jamaica, and all these places, Central America, Mexico, and even down in the South, the Spanish had a lot of colonies there in Florida, all the way up to the Carolinas. These newly emancipated Indians, the English dreamed, would gladly work for them, helping create an English